Good morning, everyone. Today is Tuesday, April 7th, 2020. It's approximately 10 a.m. Pacific Standard Time. Thank you again for joining us, Family Law Matters legal team. Today we're talking about spousal support, aka alimony. We have the entire session broken up into three major topics. So we'll walk you through that. Please remember, if you have any questions, make sure that you send them over to us. You can email us. Or simply send them in the chat room. When you come in, please make sure that you are muted. I have set the program to mute everyone on entry, so that should not be an issue. Again, today is Tuesday, April 7th. Let me start by giving the panel an opportunity to introduce themselves, and I will start with Gina first.
Hi, my name is Gina Famularo, and I'm a partner at Family Law Matters. I've been an attorney for 22 years, and I've only practiced family law that entire time.
Thank you, Gina. Colleen?
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I have been an attorney for 10 years, practicing almost exclusively in family law during those 10 years and appearing in San Diego County and Riverside County for the most part, and and then throughout Southern California.
Thank you, Colleen. Christy?
Good morning, everyone. My name is Christy Bergamo. I hope everyone's healthy and safe today. I am a senior attorney here at Family Law Matters. I've been practicing 17 years. I've been certified to be minors counsel in the courts in Southern California, which means judges appoint me to represent children. I've also sat judge pro tem in Orange County on Family Law Matters, and I'm an instructor of paralegal studies at University of California, Riverside.
Thank you, Christy. And I am Bishoy Shahada. I'm the managing partner here at Family Law Matters. I've been an attorney for a little over 2 years, and that's all I have to say. So let's get to it. Gina, spousal support, what is it?
Sure. Spousal support used to be called alimony. And what it is it is money paid by one spouse to the other for their support. It is to maintain the standard of marriage standard of living during the marriage. There's two types of spousal support. There's permanent and there's temporary. Temporary spousal support is to keep everything intact while they're figuring out the terms of the divorce, and then permanent support is to help that supported party get on their feet long term.
So when you are talking about the difference between permanent and temporary, what's the biggest difference between those two categories?
Well, temporary support is support that would be ordered from the time the parties separate to the time that the divorce is final. Permanent support goes from the time that the divorce is final to some date after the marriage has been dissolved.
Okay, and who typically gets the spousal support? Which party?
Sure, spousal support is given to people who were married. It is based upon the need of one party and the other party's ability to pay. Spousal support is only given during marriages. It's not given to people who are cohabitating. It's not given to people in serious relationships. It's only given between two married parties.
And how does the length of marriage affect spousal support?
Sure. Spousal support is calculated a couple different ways. So it could be calculated based upon some indefinite number, or it could be calculated on a date certain. So the length of the marriage is a guideline as to how long the support should last. It's not a hard and fast rule, but typically the rule of thumb would be that a person receiving spousal support would get 1/2 the length of the marriage. So for instance, if it's a 4-year marriage, you're looking at about 4 years of spousal support.
Sorry, you said 4 years of marriage is 4 years of spousal support, or 2?
I'm sorry, thank you. 4-year marriage would be 2 years of spousal support. However, if it's a 10-year marriage, 10 years or more, then support is calculated differently. It would go an indefinite amount of time unless the parties agreed to something else.
And when you say that it's based on the length of the marriage, I just want to clarify that. Is it based on the length of the relationship or the length of the actual marriage from the date of marriage to the date of separation?
It's only based upon a relationship. So the court would then look at several factors to determine whether or not somebody is entitled to spousal support. They'd look at stuff like how long they were married. Was there any abuse? What is the education level of each party? What are the ages of each party? Are there any disabilities? Is there any separate property or inheritance? They take all these factors, they'd look at them, and they determine what the ability to pay is, what the need is, and then they'd also determine how long support would go.
And when you say relationship, again, just for the viewers, you're talking about date of marriage to date of separation, correct?
Correct. You do not look at, for instance, a common question is, I was in a relationship for 13 years. I've been married for 3. I sacrificed everything for those 13 years. I quit my job. Am I entitled to spousal support? The answer is yes, but only based upon that 3-year marriage.
Perfect. Thank you, Gina. Colleen, I want to get into the process of spousal support. So how does one party get spousal support?
Well, first you need to start your case. So you would need to file a petition with the court if you're either with legal separation or for divorce. You've got to have an open case first. Then once you have your open case, you get a case number. You can file what's called an RFO, your request for orders, requesting spousal support. The court would then give you your court date along, and it's a conformed copy. There's a stamp on it, and you've got to serve that on the other party. And that's important because what happens is once you're at your court hearing for spousal support, the court's not only going to be making spousal support orders going forward, but then it's also going to be making spousal support back to the date of filing, called retroactivity. So you want to make sure you protect yourself and that you serve that that RFO to the other party as soon as possible, so that you can get that retroactivity. So that's how you start it. That's how you request it. The court does not do anything for you. So you've got to make sure you put your request in if you are in need of spousal support as soon as possible. Because like I said, the court doesn't wait around for you or doesn't say, okay, it's time for you to get your spousal support, so we're going to have your hearing. You've got to be proactive. So it's really important if you need support that you file right away.
Okay, and just to clarify, can the parties get, or can one party get spousal support orders without filing for a divorce?
I have yet to see that happen. Again, you need to have some sort of case number, and to get a case number, there's 2 different routes. One, either with a legal separation or with a divorce. So it's really something that you have to think about and think about clearly as to what your intentions are before you start petitioning the court for support. Because I think, as we talked about yesterday in our podcast, that if you're not intending to get a divorce and you file a legal separation, it could turn into a divorce. So you just have to be careful, and that's where talking to your attorney, calling our office, just to weigh those options and what the possible ramifications would be if you really don't want a divorce.
Thank you, Colleen. Christy, I want to bring you in on this topic. If the parties are still living together, will support be ordered?
It will not. That's one of the very bright line distinctions with respect to support. The idea is, or the notion is when you remove yourself from that relationship and having the ability to be able to support yourself. So the idea is you're all under one roof, the bills are being paid, et cetera, et cetera. I know that's not usually the case. In fact, I get questions all the time about, I'm living in the house with this person, but they're not giving me any money. And those are very, very distinct questions that obviously you need to reach out to us to discuss about what your options are and how we can assist you in getting the support you need. But as a general rule, no. If you're in the house with the other person and all the, arguably all the expenses are being paid, so you will not be entitled to it at that juncture.
And what if I don't know how much the other side is making or makes?
Well, the nice thing is when you go through this process, the code, not only the family code, but the California Rules of Court and local rules all require both parties to give full disclosure. So we will be able to have an income and expense declaration. We will be able to receive tax returns. We can do discovery, but there is an affirmative duty on everybody's part to disclose. Now, the follow-up question I always get to that is, well, what if we get their disclosures and it doesn't have, I don't think they're being honest, or they don't have enough on there and we can't really figure out what they're making. There are discovery procedures that we can do to gain more information. So I think as a general rule, people don't have to worry about that in either instances. So if you're the payor, you see the person who wants support and they're buying new clothes, driving around in a new car, something to that effect. It works on both parties that we will be able to have full disclosure.
And does it affect spousal support if the supported party is living with someone?
Well, we have to figure out who they're living with, and that's a very good question, B, and it comes up often. There's a difference between a roommate and cohabitating with a person that they are involved in a relationship with. These are all very complex legal issues, which again, you should reach out to us and ask these questions. Now, if it's a roommate, the question is, are they paying rent to the person they're living with? I mean, yes, that would be a factor the court would think about in terms of what the need is. And Gina talked about that in the beginning, what the need is of the supported party and the ability to pay of the payor, the person who pays the support. So if they're cohabitating, they're in a relationship with the person they're living with and they are receiving support, there is actually a family code section that indicates that there is a presumption, which means that it's absolutely a factor the court considers in maybe reducing their support or not ordering it, and it depends on where you're at in the process. This comes up most often in my practice after the long-term support's been ordered, a few years have gone down the road, and they start the supported party starts cohabitating with someone. And that is a very complex legal issue. It's very fact intensive. There's some discovery that has to be done on that. So it is something that I would suggest you receive assistance from an attorney to do. It's not that simple, I guess is my point.
This is the legitimate aspect of it, the litigated, the disputed part of it. Now, what if the parties agree to a certain sum in spousal support? Can they do that?
Absolutely. You can always come up with your own agreement. You can always, and quite frankly, in being the one that probably does the most litigation in our firm, and in fact, in my entire practice, I'm the one that's usually in the courtrooms doing these long cause trials on these issues. It's an arduous process. It requires a lot of money, a lot of time, a lot of energy. So obviously, if you can agree to something that works, I mean, judges say this all the time, no one walks out happy. If you both walk out unhappy, then the job has been done well. So if you can come to an agreement about something you both can live with and be realistic about it. I mean, that's where the conversation about, what your expenses are, what you're paying for. I have a lot of clients who say, well, I'm paying for our child's education. How can I pay for our child's education and then pay the supported party? And if we can all discuss those things and come up with a reasonable agreement, I think you're always better off trying to do that. But you have to be careful in the drafting. And I think we talked about this yesterday. I don't suggest you guys just on your own, just saying, okay, I'll give, him or her $500 a month, period. I think you need to put in any agreement what the financial circumstances are of the parties, what's being considered, how long the marriage is. I think that all goes in there, because if in fact at some later point someone wants to change that, it gives the judge a really great window into what the circumstances were at the time. So just be careful in your drafting.
Okay, now, what if the supported party does not want the support? Will the court still order it on its own?
Well, if the supported party doesn't want the support, then it's not going to be ordered. I mean, that obviously Colleen went into the process initially about how you have to file and request it. So if the supported party doesn't want it, I doubt they're going to file anything for it. And the judge is not going to make the person who's paying pay something if the supported party doesn't want it. So I think you're pretty safe there.
Thank you, Christy. Gina, do you have anything to add to this?
No, I think that that's a pretty good point, that if somebody doesn't want it, the court won't order it. And in fact, if somebody files for spousal support and then changes their mind, they have a right to do that as well, either when the order is made or going to be made or in the future. The parties can always agree to something else. And that's what we encourage as a first line of defense, because that puts the control in the parties' hands as opposed to some strangers.
Thank you, Gina. Colleen, I want to go back to you.
I want to comment really quick before we leave the subject. Gina brings up a very good point. And like I said, I have litigated the issue of spousal support for 17 years, and very, very often. It's a significant issue that's litigated. And you never know what the court is going to do, because the broad range of factors the court has to consider, it's like 14 or 15, we were talking about 14 or 15 factors the court has to consider. You don't know which one of those or how many of those are going to be, incite the judge to make a decision. So it could be high, it could be low. So to have that certainty that Gina's talking about is really important. And I think that we also have to remind the viewers that as of January 1, 2019, spousal support became a non-taxable event. And what that means is it used to be deductible by the payor, the person who pays, and it was, you had to report it if you were the one receiving it. So now that's all been taken away. So I think that's a huge factor in terms of trying to come to an agreement about spousal support, is that I think that compels you to really sit down and discuss the issue and try to come up with an agreement. Because like I said, I always have a number in my mind when I start a trial on spousal support, and it's kind of my own game that I see how close I'm going to be to what I think is going to be ordered. And most often I'm pretty close, but sometimes I've been way off, and it's really gives you that certainty to agree. So.
Well, and I just want to dovetail too off of Gina and Christy and just say that we can help you try to come up with some solutions in regards to the issue of spousal support. And what they're both saying is that the courts have so much discretion in ordering spousal support that if we can take a look at your whole case, all of your assets, we might be able to sit down and come up with some other ideas that you haven't thought of before. And that's what we really enjoy doing. So just to reiterate off of what Christy was saying and what Gina was saying, and you can come up with these agreements amongst yourselves. You're the ones in control. You know what the certainty is too. But reach out to us and we can start giving you ideas on how to resolve that issue.
Thank you, Colleen. You're here. Let's talk about spousal support and can it be changed? So can spousal support be changed after there's an order made?
Yes, just about every order, including child custody, child support, those things can be ordered. They're not, there's no, even though spousal support has a permanent order, it doesn't mean that it can't be changed. So but there's got to be a change of circumstance. You got to show that there's a change that's going on either in your income, in the other party's income, in your station in life, if you've retired. those kinds of things. So you just can't change it because I don't want to pay it anymore. There has to be facts to support your request to change it. Now, in your judgment, there could be a set of, I think Christy and even Gina were talking about this, that if the other party needs to get employed and they haven't done anything and they're supposed to be out trying to become self-sufficient and out trying to get employed, if they were a stay-at-home mom or a stay-at-home parent for a long period of time, there's generally specific language within a judgment that states that they have the duty to go out and become self-sufficient. So if there is a period of time, for example, and you don't believe they are doing anything, one, you need to consult an attorney to determine whether or not now is the time to file asking for that modification of spousal support. So just to answer your question, yes, it is, you can change spousal support. It's very fact specific. There needs to be some sort of change of circumstance. So that's where, again, you just give us a call and we can go through your judgment and then determine if now's the right time to file that RFO to modify your spousal support orders.
And does the court weigh all of the factors equally?
Well, they're supposed to. But like Christy was saying, sometimes it just, with the facts of your case, there could be something that really resonates with the judge that may or may not outweigh one of those other factors, because there's so much discretion involved when you're looking at spousal support orders. So they're supposed to balance all of them out. So it just depends.
And when you're talking about, I know you mentioned it's very case specific, and we have to pay attention to the language that's in the judgment. Mm-hmm. So your ability to change or modify the spousal support, does that depend on the terms of the judgment?
Not necessarily. It just depends. So again, you don't need the magic language if your income has decreased, you get laid off, or like, especially like right now, that your pay is drastically reduced, or maybe your pay structure has changed because now you're no longer able to make as much commissions as you were, and now your employers had to change your base salary or whatever your benefits are to keep you employed. Or that the other side is now employed. Maybe they were going to school for a long period of time. They're finally done and they're off to now become a nurse or an accountant. These are actually examples in some of our cases. So you don't need specific language to modify your support unless in your judgment it has there's a big paragraph about non-modification clause within respect to spousal support. That also just needs to be looked at by your attorney, just so we can take a look at it as well, and if any exceptions apply in that situation.
Okay, and then what if the payor does not pay?
So that's what's called the collection issue. So you have a court order that they're required to pay a sum certain, and there's a variety of things in which you can do. One, you can get a wage garnishment, income withholding order that you file with the court, and then you've got to serve it on the other party's employer. And then what that does is that the employer gets that court order, and they're going to, on the document, it shows how much is supposed to be withdrawn or taken out of that person's paycheck. They can only take up to a certain amount. They can only take up to 50%. But essentially, when the payor gets paid, you're also getting paid by their employer. You're going to be getting a check. So you could do that. You can, there's contempt motion. There's other remedies with the court. If they're still not paying, or for whatever reason, you're unable to get an income withholding order. Sometimes with self-employed people, that's very difficult to do. You can file a motion asking for enforcement and asking for attorney's fees and arrears determination and an admonishment by the court. You can also file what's called a contempt of court, that they have the ability to pay, they're just choosing not to pay you for whatever reason. They were present in court, and the court can punish that person with a wider variety of tools by the court. Contempt motions, though, is not something to be taken lightly. They're very complex. They're very difficult as well. So that is something you'll need to speak with an attorney. I don't recommend you trying to wade those waters by yourself. It's also can be time consuming as well. And I don't think people understand how exactly it works, because it's involves there's criminal criminal penalties involved. Public defenders can get involved. So it's not something to be taken lightheartedly. So that's something you really need to speak with an attorney before you contemplate filing a contempt action.
And what about the flip side? What about if the payor can't afford to pay the ordered spousal support? What can he or she do?
Well, it's kind of working backwards. So if you're in a situation where maybe your income has changed, maybe you're looking at going into retirement and your income is going to be going down, you're unemployed, whatever the situation. And I think we've kind of highlighted this in a couple of other podcasts, but especially as it's relating right now to the current economic situation and the job market, that if you experience a change in your income, you've got to, we've suggested reaching out to the other party, see if you can work something out and explain the situation. If that doesn't get anywhere, I wouldn't wait very long, because you want to make sure you file an RFO to modify your spousal support order based on your, again, this phrase, change of circumstances, your change of income. Because like I had explained before, starting spousal support, if you need spousal support, you want to file right away to preserve retroactivity. And I know we've talked about this in other podcasts. You want to protect yourself too if you're unable to pay by filing your request to modify your spousal support as soon as possible, because then the court also goes backwards with your retroactivity request and going forward with modifying your spousal support. So you want to make sure you get to the court as soon as possible with that change if you've experienced a change of circumstance. Because you're still on the hook, essentially, because there's still a court order in place.
Okay. And the last question that I have for you, Colleen, is what if I find out I'm the payor and I find out that the other side no longer needs the spousal support? Is that along the same line of filing a motion with the court and putting forth those facts?
Well, if you find yourself in that situation, good for you. What you want to do, though, because you're still not off the hook, if you just got an email or a phone call or whatever from the other party saying, hey, for whatever reason, I don't need spousal support anymore, the next step you got to do is you got to get that into some sort of agreement, a written agreement that you can file with the court. So we want to draft a stipulation to terminate support, and we want to do that right away. And if again, it's the same thing, that if you are in that situation, you don't want to wait too long, because you want to get that motion to court saying, I need to terminate spousal support so she can't come or he can't come after me saying I'm not paying anymore. So again, it's either you got to get an agreement in writing saying that the spousal support is terminated, you no longer have to pay, or then you've got to ask for the court to terminate spousal support to protect yourself.
Thank you, Colleen. Christy, I want to get back to a point that you made earlier about cohabitating. And I want to talk about if I'm the payor and I find out that the other side is cohabitating, can I just simply stop paying support?
No, you can't. And I can't stress this enough, because again, I've litigated this issue quite often. And it kind of piggybacks on what Colleen was saying, and then I'll answer your question, verbal agreements don't work in any of these instances. They don't work. I have spent a lot of days in trial over whether or not there was a verbal agreement or not. It's expensive to verbally agree. I know it's expensive to hire a lawyer, but it costs way less to reduce it to a writing and file it with the court than to get into some litigation years later over whether or not there was a verbal agreement. So that is not a good strategy, and it's not something anybody should be doing. So if you find out that your ex-spouse is cohabitating with someone, the analysis isn't just, oh, they're living with someone, I have to quit paying. No, it's more complicated than that. Not only if they're cohabitating, there is a presumption that there's a reduction in need, but nowhere in the family code does it ever state that, oh, they're cohabitating, reduced to zero. So it is something that is very fact specific, and something that you really need to contact us about, because that's just the tip of the question. And I'll tell you that just because they're cohabitating doesn't necessarily mean that their spousal support is going to be set to zero. Now, it might be reduced. And again, it depends on the facts. How long they've been cohabitating. And really what the question is the cohabitation is not just living together, but are these two persons acting really like spouses? Because one of the ways that you can, spousal support is terminated by operation of law, which means it's in the code, is that the other spouse remarries, okay? So what the analysis is it looks like a marriage, it smells like a marriage, it is a marriage other than the marriage license, right? So that's really what we're looking at and what the nature of that relationship is. And we can do discovery in terms of trying to get that information. Because again, the follow-up question is, how do I prove it? How do I prove what they're doing? How do I prove that they're sharing finances? And there's a lot of ways to prove that. So again, it's just a good idea to call us and let us know what the issues are, and go from there. So, but just don't stop paying. You need to file something. We've said this over and over again. You need to file something to preserve your rights, your retroactivity, which means the court can go back to that filing date and service date of the request for order and make changes. So it's huge and it's imperative.
Thank you, Christy. Would you like to add anything? Nina, can you hear me?
Yes.
Would you like to add anything?
Just that, as Christy knows, there's actually a new case that came down, and even if somebody's remarried, even though by operation of law, it says that supports will stop when the supported party remarries, that still needs an attorney to review, because even that is not an automatic anymore. So be careful and don't assume, as both ladies have been saying, that you have an agreement or you have an understanding. Don't assume that's the case and find out 5 or 10 years later that now you owe all this money. Immediately seek counsel and ask them to review your judgment. We cannot stress that enough.
Thank you, Nina. Colleen, any closing remarks?
I think one of the acronyms that I've been trying to come up with is PP. You got to preserve and you got to protect yourself. So just keep that in mind. Preserving and protecting yourself means filing a motion, getting to court if you do not have a written stipulation, an agreement in writing.
Perfect. Thank you, Colleen. Well, I do want to take this opportunity to thank all 3 of you guys for joining me today. I want to thank our listeners and our viewers, and don't worry if you weren't able to join, we'll post it on our social media, our YouTube, our website, and our Facebook page. Feel free to listen to them. You can also download them. And if you have any questions, please feel free to reach out to us. You can do it in one of 3 ways. The first and easiest is you pick up the phone and call 951-587-0505. You can also email us at info@temeculadivorce.com, or you can simply schedule a consultation on our website. The website is www.temeculadivorce.com. And again, thank you all for joining me, and I hope that everyone stays safe and sound. Thank you.
Thank you.
Bye.